Good morning, everyone. Welcome to the Office for Prevention of Family and Domestic Violence webinar. My name is Nicole Leggett and I'm the Executive Director of the Office. I'd just like to start by acknowledging that I'm joining you today from Wyalup on Whadjuk Noongar Budja and extend my respects to Elders past, present and emerging, and also acknowledge the traditional custodians of the lands that you are all joining this webinar from today. We'll just get you to move across. So today's webinar will run a little bit differently to probably what you are used to. I'm going to offer a little bit of an update about some of the work and activity that's been occurring, particularly over the last week in the national policy space, particularly in the run-up to a National Cabinet meeting next Friday, which will be focused on family and domestic violence. After that update, we have two guest speakers today. We have the Commissioner for Victims of Crime, Caddy Kraslin, and we have Tanya Elson from the Centre for Women's Safety and Wellbeing. And Caddy and Tanya will be talking to us about the work of her office, including legislative reform that's currently on foot. And Tanya will be talking about two information sharing projects that the Centre is leading on. So as we normally do, I'll encourage people to post their questions in the chat as they think of them, but we will deal with them at the end of the presentation and I will point them to Caddy or Tanya as appropriate, depending on what the question is. So I guess with all of that said, I'll head into my brief update before I hand across to Caddy. I think everybody would know and be aware that on the 1st of May of this year, National Cabinet, which is the Prime Minister and all of the premiers or state government leaders from states and territories, met to talk about family and domestic violence. And that particular meeting came on the back of a number of critical incidents around the country, a number of family and domestic violence related fatalities, and also a number of rallies and significant kind of advocacy platforms around the country about investing more and, you know, essentially doing better for victim survivors of family and domestic violence. So at that 1st of May National Cabinet meeting, the outcomes that were publicly released were that National Cabinet, inclusive of all state and territory First Secretaries and the Prime Minister, were essentially tasking various ministerial advisory groups and various sort of existing governance groups to take forward a body of work to report back to them on the 6th of September. So we are coming up very close now to that 6th of September report back in National Cabinet. So what I've got on this slide here are the things that were tasked. And also a link to the media statement that gives a recap on that meeting. But essentially, police ministers and the Standing Council of Attorney Generals were asked to develop options for improving police responses to high risk and serial perpetrators, including consideration of focused deterrence and fixated threat strategies. There was a tasking around improving information sharing around perpetrators. There was a task around national consistency and best practice in relation to family and domestic violence risk assessment and in relation to sexual violence responses. There was a piece of work tasked to the Commissioner for Domestic, Family and Sexual Violence, working with Department of Social Services and the Office of Women to do a rapid review around prevention. And then there was also acknowledgement at that meeting about a body of work that had already been in progress through the Senate inquiry into missing and murdered First Nations women. So understanding that that was a critical input to the thinking of National Cabinet coming back together on the 6th of September. Just get you to move across, team. So what I wanted to give you some visibility to, as I'm sure many of you would already be aware, is that some of this work has started to come together in the form of public-facing reports. So I just wanted to give you some early kind of visibility to those reports, understanding that they've all had their own press and media statements, but these will be the things that will be considered as part of that National Cabinet meeting next week when it reconvenes. So firstly, last week, we saw the Senate inquiry into missing and murdered First Nations women and children released. The report, which we've included a link for here, has 10 recommendations, but the body of the report and the findings also contains a wealth of information that really significantly should inform and shape policy development into the future. We've also seen the Commissioner for Domestic, Family and Sexual Violence release her yearly report to Parliament. So this is actually her second report to Parliament, but the first one was released quite soon after the establishment of the Commission. So it wasn't to its full kind of, I don't know what the word is. It wasn't as comprehensive as this report is, if I can put it that way. So part of the role of the Commissioner is to help promote transparency and accountability around delivery of the national plan to end violence against women and children. And this report speaks to the Commission's view of progress against the national plan. So it speaks to key findings across 5 chapters, and they heavily lean into themes around workforce development, embedding and hearing from lived experience, improving the capacity of systems to respond to family and domestic violence, and engaging men and boys. So again, the link to that document is provided. And then the third report, which we saw released on Friday, is the report of the rapid review into prevention approaches, which was co-convened by the Commissioner for Domestic, Family and Sexual Violence, working with the Office for Women and the Department of Social Services and a panel of experts that they brought together. So that report was released on Friday. It's quite an extensive report. It makes multiple findings and has 21 recommendations, the majority of which are multi-part recommendations. So it's a bit difficult to do justice to a summary just in the very limited information that we've got here, but it's certainly a very comprehensive piece of work that speaks to all the facets that need to be considered in ending violence or preventing violence into the future, including about authority and leadership, so where that's held into the future. And then they talk about prevention on a wider continuum, including into response. So that's probably the third piece that will significantly influence and input to that National Cabinet meeting that we know is occurring next Friday. So I guess with that said, much like yourselves, I suppose I am on the receiving end of this information. I'm, trying to work through it and try and understand what it might mean and what it might mean for us, particularly here in WA. But I expect that some of that will become clearer following announcements next Friday, at which time we can circulate some further information. So please don't hesitate to post questions in the chat if you have questions you would like to ask about any of this work. But I guess without taking up too much more time, I wanted to introduce the Commissioner for Victims of Crime, Katie Kreslin, who's going to talk to us about the work of her office, including the legislative program that they are currently progressing. So thank you, Katie, for joining us this morning.
Thank you, Nicole. I think my camera's come back on. So hi everyone. I'd like to also acknowledge that I am on Wujak Noongar Boodja and pay my respects to elders past, present and emerging, and also to acknowledge the findings of the Murdered and Missing First Nations Women and Children report, which I think we need to all look at the findings and take note of. So I'm just going to do a bit of an overview of the current activities of the office people may be aware that there has been some legislation both passed and introduced, and I'll just cover off on what those pieces of legislation are. So go to the next slide. So I'll talk about current legislation, talk a bit about where we are with election commitments that you might be aware of, coercion and control, and also our activities under the Family Violence Reform Plan. So going to the legislation, the Family Violence Legislation Reform Act of 2024 was passed by the Legislative Council last Thursday. I don't have a proclamation date yet. I think that is coming to me, but we do know that this will be sometime around December. So the Act introduced a number of items, but it focused primarily on the use of mandatory electronic monitoring, both at bail and sentencing. So it says that if an individual who is subject to a family violence restraining order and is subsequently accused or convicted of a further family violence offence will have to have electronic monitoring except in exceptional circumstances. So that will happen at the first bail hearing or at their sentencing. The second is if you are a serial family violence offender who is then accused or convicted of another family violence offence, that you will be required to have electronic monitoring. The previous was that you should be considered, but now it's mandatory. The final group is those who are subject to a family violence restraining order and are released from prison under an early release order or a post-sentence supervision order for a family violence offence. You would also be required to have, excuse me, mandatory electronic monitoring. So in order to manage the impact of these reforms, the Police, Community Corrections and the Office of the Commissioner for Victims of Crime have all requested additional staffing to manage the outcomes from this. This means that matters will be considered on the weekend as well, which we understand currently isn't happening. So that's step one. Also, the person who breaches the directions set by the Community Corrections Officer can be immediately arrested by police without a warrant. So if you breach the directions, which are the areas at which you can and cannot go if you're subject to electronic monitoring, you can be immediately arrested. Tampering with the device has already been subject to previous legislation which increased the penalties. So that's the electronic monitoring components. The numbers of people likely to be on electronic monitoring now across the state are above 400 to 450. And we're still working through what's an exceptional circumstance to not have an electronic monitoring device. The Act also introduced a definition of coercion and control into the family that should read, the Restraining Orders Act of 1997. So there is a new definition which says that it is a behaviour or a pattern of behaviour that may occur over a period of time, maybe more than one act or a series of acts when considered cumulatively coerces or controls the family member or causes them to be fearful, and is to be considered in the context of the relationship between the person and the family member. So that has come into effect into the Restraining Orders Act. Also, it doesn't limit it to intimate partner violence, so it is within the defines of a family relationship that exists within the Act. So all types of family relationships can be considered. So that's child against parent, intimate partner violence, but importantly also people in disability circumstances. A family relationship extends to a carer. The last component in the legislation was in response to recommendation in the Coercion and Control Report, which is on the next slide, which acknowledges children as victims of family violence in their own right. So it amended Section 3(1) of the Restraining Orders Act into the definition of a family relationship. So it is one of whom in that is a child who ordinarily resides or resided with, so it takes into account separation, or regularly resides or stays, or resided or stayed with the other person. So that now allows children to be considered victims of family violence in their own right through the observation of violence, as well as being the victims of the violence. So that's the Family Violence Legislation Reform Act of 2024. Other pieces of legislation which I think are of importance are the Criminal Law Mentally Impaired Act of 2023 comes into effect on the 1st of September, so on Monday. This will fundamentally change how we manage people who are considered by the law of unsound mind, most importantly for victims and also for family violence victims, particularly where it's been a family member that's been injured, is that a large number of people may be released from prison under this act. We have contacted all of the victims involved, advised them of the changes that are coming along, advise them of what their rights are now under this act. So if you have anyone who you're in contact with and they are wondering about what does this actually mean, please ask them to call either my office or to call the Director of Public Prosecution's office. The last piece of legislation which was introduced and is unlikely to get passed, if we can go back, is really a really massive bill. It's the New Evidence Bill of 2024. This will bring us into line with other jurisdictions through the Uniform Evidence Act. It will increase the range of special witnesses. So that will mean that family violence victims in superior courts are automatically a special witness. It will allow for witness intermediaries, disallow improper questions, which is where a victim is harassed, bullied, intimidated, or there's repetitive questions, or the manner or tone is insulting to the victim. So it's a very significant change. And also will introduce body-worn camera evidence as evidence in chief. So this bill is currently before the Uniform Legislation Committee. You'll be aware that we do not have a lot of time this year before Parliament rises. So it's unlikely, I think, to get passed this year, but we don't know. But it will have a very long proclamation date due to the amount of training required. So that's the legislation update at the moment, and I'll just quickly go through the projects. So currently we have the Leave Safe, Stay Safe project, which was an election commitment to give women prisoners the best chance of breaking the cycle of family violence, really understanding that the majority of women prisoners, we're at 85 to 90%, are a vulnerable group who all report rates of family violence or sexual violence. So the project has been operating now particularly well. We had some issues in Geraldton that people might know, but that's been resolved. All women will learn about online safety. They get a clean smartphone. They have one-to-one social support and legal advice, and they have awareness training. So we have 60% of respondents reporting an improvement on the key metrics, but importantly, we have over 80 to 90% of people in the program saying that they were of great assistance. And we're hoping that this will have two things. One is that the women won't re-engage in a violent relationship. And secondly, then not have to engage in criminal activity and return to prison. The other project is the forensic service, which is now operating on police referrals. So this has been piloted for a year with the DPP. So we're looking to collect clinical forensic evidence and medico-legal reports to support family violence investigations. The DPP have given us incredibly positive feedback on the use of these reports in encouraging perpetrators to see that the trial will proceed and that there is sufficient evidence to convict, so they are pleading guilty. The community component is wraparound support and very much focused on supporting someone through a legal process. So that's 2 projects that are now embedded, and we like to see them as business as usual. Moving on to coercion and control. So as indicated in the report, we are on that pathway towards what does criminalisation look like. The steps we're currently doing is reviewing all of the legislation really well. So we're looking at a number of issues in the Restraining Orders Act, in breaching of restraining orders, how the criminal code sits in this space, in particular stalking and electronic issues, and finally the Victims of Crime Act to allow for a greater capacity to review matters. We also have the statutory review of the Intimate Images Act, where we know that we probably don't have the charges we wanted, and what can we do to improve take-up in that space, particularly where there's threatening to send images. And finally, reviewing the Family Violence Legislation Reform Act of 2020, the 2 big offences being the persistent family violence offence, which goes to coercion and control in particular, and secondly, the non-fatal strangulation offence, as well as all of the other provisions. So the stat review of intimate images is currently finalised and is awaiting to be sent to the attorney, whilst we have just commenced doing the work on the Family Violence Legislation Reform Act. So the next one is that we were funded through the Family Violence System Reform Plan to look at a disclosure scheme, which sits under the information sharing pillar. People would be aware that there was a report released in the last couple of months from Monash, which was part of an Australian research grant, which looked at the use of disclosure and register schemes, which we will take on board the findings of that report very strongly in what we do. The report did not find disclosure schemes to necessarily offer the level of protection that people wanted. We will have options to government for consideration in the first half of 2025 or the end of 2024. So we are working on that one right now. And finally, we also have the use of victim advocates, which is Criminal Justice Victim Advocate Pilot Program. This is to provide end-to-end support for victims as they move through the criminal justice system. So this very much isn't about providing a number of the services that already exist in the community. This is very much a legal advocacy model. It is where there's a consistent source of information, somebody who can work with the victim and the police during the investigation phase, can provide information on what to do, is advocating for the victim. So if the police come to talk to the victim about changing the charges or doing issues, there's somebody who can assist in that process. They'd also be the person that goes to court as the support person, so that they're known to the court and they understand the role. And also if there's an unhappy outcome, either maybe a acquittal or a sentence that people don't think is appropriate, there's someone who can have those discussions with the police or the DPP and the victim to assist them. What this is trying to do is to look at reducing case attrition, because too many people withdraw from the process, encourage reporting and provide a supportive environment. Things we're looking at is, do we need to have some legislative framework that provides some independence for the advocate and that gives them protection from being called as a witness. How does it fit within our counselling confidentiality provisions in the Evidence Act? And how and whom are the best people to do this work? And how does it fit with the CLC space, the community legal centres? Once again, we're looking at service model options. We have a fairly substantial research project underway looking at all of the options across both national and international, and we will then go to government in the first half of 2025 with what an advocate looks like. Although we're focusing on family violence very strongly, we also see this as incredibly important for victims of non-family violence, sex assault, and also victims of homicide in the space, particularly when the homicide has been a domestic and family violence homicide. Excuse me. So that is currently work, and whether we should enshrine an advocate in the Victims of Crime Act. So that's the key work that we're doing. I know that it's been quite rushed. Really happy to talk through any of those components. Also, once we are clear on a proclamation date for electronic monitoring, we'll have a discussion with Nicole about running a very specific training seminar about what will be happening in that space, how we will be contacting victims, the information that the victim may need to provide in order to ensure their safety, and what do we do in those circumstances, which we're very aware of, where the victim doesn't want to provide a location because that would identify where they are. So we'll be back in contact with all of you in that space to ensure that we're providing the safest and most holistic victim service we can. Thank you.
Thank you very much, Katie. That was incredible, and I really welcome that offer about coming back via this format at the appropriate time to talk about sort of next steps and what might be available for people with that, with respect to information or referral pathways for victim survivors. So thank you very much for your time this morning. I'll just prompt everyone about posting their questions in the chat, and we'll have an opportunity to get to those at the end. And without further ado, to introduce Tanya Elson from the Centre for Women's Safety and Wellbeing. And Tanya's also going to be talking to us about system reform plan related projects, specifically in the information sharing space. Thank you, Tanya.
Thanks so much, Nicole. Thanks, everyone. Look, Katie's given a great introduction, given that a number of the projects that she discussed already sit under the pillars of the system reform plan, and you'll all, there on the next slide, you'll all be very familiar with those. So this is just provided to orient you to what I'm about to talk about. So as you know, the system reform plan developed through the work of the task force, and its wide consultation has those 4 pillars of workforce development, information sharing, risk assessment and risk management. I'm going to talk about 2 projects under the information sharing pillar that the Centre for Women's Safety and Wellbeing will be working on over the next 12 months. So on this slide, you'll see there are those 5 high-level actions committed to under that information sharing pillar. And Katie's already spoken around the disclosure scheme for victim survivors and the work that her office will be leading on that. You can see the first 2 actions there are around supporting better information sharing within the existing legal frameworks that we have, and enhancing information sharing between specialist FDV services. So I'll go on to talk about what the work that we'll take forward with you over the next 12 months will look like on the next slide. So that first piece of work, which is about how do we better support information sharing within the existing legal provisions that we have, recognises that we have a number of acts, regulations, policy frameworks that allow us to share information between specialist FDV services. However, the extent to which that happens in practice it varies, and it depends on a number of factors, such as organisational culture, the relationships that exist between the parties sharing information, and the extent to which we have in place structures that that guide us and give us a clear system to understand what we can share and how we can share it. So to address some of that complexity, the work that we'll take forward will have the first part of it will be to identify, our baseline. What are those existing frameworks, and be really clear about what exists to facilitate, enable information sharing. And that's across government, the community sector, and Aboriginal community controlled organisations. Following that, so that's work the centre will start, and it builds on work that exists elsewhere. And I'll just make the point here before I go forward that in both of these projects, we're really mindful of the amount of work that has already been done in this space and the amount of engagement that has already occurred. So throughout the planning and throughout the process, we'll be trying as much as possible to walk that fine line and achieve that fine balance around building on what we already know, not duplicating work that's already been done, and not duplicating consultation and engagement that's already occurred, but recognising where do gaps exist in our knowledge and where do we need to consult and engage to develop that full understanding. So from that baseline understanding of the enablers for information sharing, the centre will engage in a wide consultation with specialist support services and victim survivors, and that will be to develop a really fulsome understanding of those barriers at both a practitioner and an organisation level that inhibit information sharing, and to get a sense of what information is already being collected by services, and to identify examples of existing good practice that we can build on and nurture, and to get a sense of what sort of resources would be useful for our services within our specialist service system to support and promote consistent information sharing, so that we can strengthen our risk assessments and our risk management processes. So in a sense, what's getting in the way, what's working well, and what do we need to take this to share information more effectively. And then finally, the last piece of this work is to develop the resources and the training content that can be that can exist and be used within our sector on an ongoing basis to provide that guidance, and to then promote that and raise awareness of that within services. So that's the first piece of work. I'll just go on to the next slide, which is about the second project, because I'm conscious of time. I feel like I'm rushing through this and I apologise, but please don't hesitate to raise questions in the chat. The second piece of work is around how do we use our existing systems to better share information. And the focus of this project will be around SHIP, which I know you're all very familiar with. And we know that it comes with a number of challenges in terms of the extent to which it is useful as a tool to share information within and between specialist services. So this work is about, well, I'll take a step back there. SHIP has built, as many of you or all of you may know, with more functionality than we currently use. And so this project is about how can we better use the potential of that functionality so that we can leverage it to better support information sharing and improve our risk assessment and improve our collaboration within and between services. So the first part of this project will be looking at how is SHIP used elsewhere in other jurisdictions across Australia. What's working well there? What can we learn from how it works? And what can we learn about the risks and opportunities that exist within that idea of better using the SHIP potential? From that point of view, from that review, we will take that baseline understanding and then engage in quite a robust sector consultation engagement process to have conversations together about how we might use SHIP differently, how we can build on what already exists. What are your thoughts and views around some key considerations such as privacy and consent and confidentiality, but to get a sense of our readiness as a sector to embark on a process of more fulsome use of SHIP, to get a sense from you around what information will be beneficial for sharing within the SHIP platform that is not already shared and fully utilised. What sort of workforce development and support and guidance is needed to support that, and what are the key considerations that we need to get right, really understand and get right around how do we share data information for Aboriginal people and other priority populations. So they're two big pieces of work. We have a 12-month time frame for both of those. They will be, I'll just go on to the other slide. No, they will be guided by, the governance mechanism that supports the system reform process. So under those pillars of the 4 pillars of the system reform work, each pillar has it's gone right out of my head, but each pillar has an advisory group with representatives from across the sector information sharing working group, sorry, I've just remembered, who will exist as a guidance and a consultation mechanism for the planning and the execution of that work. And they report to the implementation oversight group for the system reform plan. So we have those touch points to not only guide the work, but to help ensure that across the number of initiatives underway throughout the system reform plan, we are, as I said before, we are making good use of work that has already been done or is occurring under other pillars, and also doing our best to make use of existing processes of engagement. So we're not duplicating that. We're not duplicating the number of times that we are asking people to have input. We can try and consolidate that for maximum effect. So hopefully that group will support some coordination and some efficiencies to streamline a number of those pieces of work so that we can make the best use of your time as we ask you for your input and your thoughts about what this should look like going forward. So that's probably enough from me, because I think we're at 11:40, and but don't hesitate to reach out to the centre if you would like to know more about those projects, and as we get them underway, we'll be communicating that to you through our own our e-news and other mechanisms, and by contacting you directly for input. But I'll stop now and hand it back to Nicole for questions. Thanks.
Thank you so much, Tanya, and thank you for being available this morning. It's great to see both of those projects getting well underway, and I just think, like many of the things that are being progressed as part of the system reform plan, and Katie spoke to some of her work in that space, they're things that I think will help to make a really tangible and positive impact. So really exciting to see them start to take shape. So thank you, Tanya, for talking us through that. I'm going to turn our attention now to the questions that have come forward in the chat. Caddy, just letting you know in advance that there is one question so far for you, but there's one for me first. So I'll answer that question first, and then I will put a question to you. So the first question that's come through is, was there any WA organisations consulted in the rapid review? And that's the rapid review led by the Commissioner with the panel of experts. I didn't see any consultations or forums for this being held here in WA. So I think that the answer to that question is that mostly the panel was drawing on existing consultation material and existing literature. However, I am aware that they did consult with a range of federal groups, if I can put them that way, like advisory councils and existing forums that have representation across states and territories to get additional information and details. So, probably the most direct answer to your question is I'm not aware of any face-to-face consultation that occurred in Western Australia, though I am aware that there were some individuals from Western Australia who were part of the consultation because they're members of broader Commonwealth governance bodies. So I also had a quick look at the report while Caddy and Tanya were presenting, and there's no account in there of stakeholder engagement, so that also didn't reveal anything further in that regard. So I'm sorry, don't have more to offer on that. The second question is, and this one's for you, Caddy. Are there any studies or evaluations being done that can be shared or be made publicly available on offender behaviour change programs in prison? Particularly interested in violent offenders, including serial offenders, having done programs and their subsequent reoffending.
There's a significant amount of literature in the research documents on behaviour change programs in prison and evaluations. I will have to check with the WOXA who sit with us where there was some work being done. There's also some commissioning work being done on behaviour change programs. So yes, there have been lots of studies, there have been lots of evaluations. I'd have to check where the current West Australian ones are up. There's also been some work done on the cultural appropriateness of behaviour change programs, and also how this all fits into ensuring that the right program is delivered to the right offender at the right time, which is part of the program evaluation component.
Thank you, Caddy, appreciate that. So I'm just going to pause for a minute because there aren't any other questions in the chat. So I'll just give everyone a minute to post anything that they're interested in hearing an answer to. It doesn't look like we've had any further questions come through. So what I will say is that if you think of a question or if there's something that comes to mind after this webinar, please don't hesitate to contact the office at the email address that is on your screens now and that will be in the slides when we send them around. Or if any questions happen to come into the chat, we'll provide a response to them directly. So if I can just say thank you everyone for your time this morning, but particularly a huge thank you to our presenters, Tanya and Caddy. It was wonderful to have you. I think that it's so important for us to be thinking about, but also contextualising all of the work that's ongoing, and particularly the reform work, in a really good and solid understanding of all of the things that are happening and how they might influence and impact on each other, but most importantly, how we can support and leverage so that we get the best collective impact out of all of our work. So thank you both for your time. I really appreciate it. And I hope that this is just the beginning and that there'll be other opportunities for us to talk about all of these various projects further into the future. So thank you, everyone. I'll leave it there.